Hello everybody. In the past few months, there has been a number of rape cases in India after the horrendous crime that is committed in Delhi in the moving bus. But still, nothing has a deterrent effect to prevent the criminals from committing such an offense. What can be the main reason of it? One of the main reasons is that our judicial system still cannot dispose of the cases in a time frame. Still, the cases linger on for years and years. So today I have decided to talk about that how Indian judiciary can decide at least the heinous crimes like the murder and the rape cases within a set time frame, and let us take this set time frame as a period of 6 months. Justice delayed is justice denied is a legal maxim, which means that if a legal redress is available for the party that has suffered some injury but it is not forthcoming in timely fashion, then the same as having like no redress at all. Justice Georgia said that without justice life would not be possible. If it were, it would not be worth living. Justice means the proper administration of law. It means the fair and equal treatment of all the individuals under law. In India, Constitution is considered as the supreme law of the land. It is the good norm. Even the preamble of the Indian Constitution has placed the justice higher in comparison to other features of the Constitution. People used to go to justice or say judiciary in the quest of justice, but at present our society has become a victim to the dialecticness of the judicial system. In India, still large number of people are illiterate and poor. They spend their hard-earned money to get justice in the court. They pay money for court fees, wakalatnama, advocates, law clerks, and other expenses in the courts. The time flies in the hope, but still keep waiting for it. They became gradually destitute by selling their assets, a property, to meet the fees of the advocates, the expenses of the courts, etc. But still they don't get justice. If justice is to be made accessible to all, then it must be relieved from the laissez-faire pattern, where justice is like any other commodity that can be purchased, and in order to that we have to make the or educate the populace. There are cases where the aggrieved person died even without getting the justice in time. They are deprived justice because of the failure on the part of the judiciary to provide justice to the aggrieved party in timely manner. It will not be wrong to say that people in India are losing their faith in the judiciary, or I might say that they have lost their faith in judiciary. In the words of K.G. Balakrishnan, the Honorable former Chief Justice of India, the people's faith in the judicial system will begin to wane because justice that is delayed is forgotten, excluded, and finally discharged. In India, quick and prompt trial of the criminal offences is the need of the hour to depose faith of the people in the judiciary. For this purpose, the constitutional guarantee of the speedy trial is one of the safeguards. The right to free legal aid and speedy trial are implicit in Article 21 of the Constitution of India. But the first written articulation of the right to speedy trial was appeared in 1215 in the Magna Carta, where it was written that we will sell to no man, we will not deny or defer to any man the justice or right. Article 21 of the Indian Constitution declares that no person will be deprived of the justice, no person shall be deprived of his life and the personal liberty except according to the procedure laid by law. Justice Krishna in Babu Singh vs. State of UP remarked, our justice system, even in grave cases, suffers from the slow motion syndrome, which is lethal to the fair trial, whatever the ultimate decision may be. Speedy justice is a component of the social justice since the community as a whole is concerned in the criminal being and the finally punished within a reasonable time. Even in the case of Sheila Bose vs. Union of India, the Supreme Court of India has held that right to speedy trial is the fundamental right of every citizen. Further, it was stated by the Honorable Apex Court that the consequence of the violation of the fundamental right to speedy trial would be that prosecution itself would be liable to be quashed on the ground it is a breach of the fundamental right. Now, Indian judiciary can decide rape and the murder cases within a set time frame, say it be 6 months. But for that, we need to look into the reason for such a delay in the justice delivery. There are various factors responsible for the accumulation of the arrears of cases, and these arrears of cases are responsible for the delay of justice. First of all is the procedural delay. The failure or inability to streamline the procedure in the civil and criminal procedure codes is responsible for delay in delivery justice and the accumulation of arrears. Example, the delay in taking up the case in trial from the time the case is admitted. Now the second one is the inadequate number of judges and courts all over the country. The inadequate number of judges and courts in country, but taking into consideration the population of the country and the pendency of the cases. The government has not only failed to increase the number of judges and the courts in India, but rather it has failed to fill up the vacancies in the courts, and cause of which the arrears of cases in the justice delivery systems are increasing with the alarming rate. Now the third one is the bad infrastructure of the lower courts. Irrespective of the fact that the Supreme Court and High Court of India are having good infrastructure, but the condition of the lower court is pretty disappointing. The lower courts have no convenient building or facilities like good library, requisite furniture, sufficient staff, and reasonable space, due to which it takes more time to dispose of the cases. Now, fourth one is the unaccountability of judges. Sometimes, considering the judicial system is independent and unaccountable by the courts, generally gives leisure and comforts to the judges, which ultimately lead to delay in deciding the matters and the accumulation of the arrears of cases. Now, the fifth one is the ability of the lawyers or habit of the lawyers to take adjournments. Adjournment granted by the court on unreasonable ground is one of the main reasons for the delay of the cases. Some lawyers seek adjournments just to harass the opposite party and to extract money from their clients. In most of the government related cases, adjournments are regularly sought for filing affidavits because the office of the central and state governments are inadequately staffed and equipped. Now the sixth one is the endless amendments of law. No matter the society is dynamic, and there also lies the need of amendment, and Indian laws are amended time and again. But as a result of these amendments, it takes time to understand and explain the new provision of law. According to late Mr. Nani A. Palkiwal, the tragedy of India is the tragedy of the wastage of national time, energy and manpower for grappling with the torrential countless amendments and explaining the new provision of laws. Now the seventh one is the vocation of the courts. Apart from the procedural delays and other factors leading delay in the disposal of cases and accumulation of arrears of cases, number of holidays and vacations in court plays a vital role in the aggravation of this problem. These are some of the reasons for the accumulation of the arrears of cases in the court of law, which further results in the delay in the justice delivery system. Now, if the judiciary has to dispose of the murder and rape cases within a period of 6 months, in that case, there are the basic issues to be looked at first, and then other measures specifically for the speedy disposal of murder and rape cases are to be formulated. Now, I would like to suggest certain measures by which judiciary can decide rape and murder cases within a period of 6 months. First, there is a need to provide proper training and vocation to the judges on regular basis to improvise the drafting, hearing and the writing skills. Skill of taking correct and fast judgment. Another important factor which must be included is judicial accountability. Second one is that at present there are fast track courts have been established all across the country so as to provide speedy disposal of cases, mainly the heinous crimes like in rape and the murder cases. But still this fast track court has to entertain civil cases also. So there is a need of establishment of the fast track courts for disposing of only murder and rape cases. Third one is that to dispose of the cases within a set time frame, there should be effective management of the courts. Time scheduling should be done, that is, the trial court should prepare the complete schedule and fix the dates for all the stages of the suit, right from the time when the case is admitted in the court till the pronouncement of the judgment. And the courts should strictly adhere to the set schedule so that there is effective management of the time leading to effective management of judicial system. Fourth is that there is a need of amendment so that procedural delays do not occur. Moreover, the state must assure that there is a timely appointment of judges and adequate number of courts, not only to cope with the workload but rather to provide speedy disposal of cases and to assure that justice is being delivered in the court rather than judgment merely being passed. Further, for the disposal of murder and rape cases, the court should adopt strategies which must include an improved justice delivery system. That is, no irrelevant adjournments, keeping a check on the application for exemptions, stopping lawyers' tendency to linger on the cases, and so on. Another one is that there is an immediate need to improve the basic infrastructure and facilitate the management of resources. Modern technology and use of computers could also increase the efficiency of the court system. Irrespective of the fact that our Supreme Court and High Court are having good infrastructure, but still, it is quite the opposite in the lower courts. The lower courts are the basic institution of our justice system, and it would not be wrong to say that it is the lower courts where the skeleton is given the required flush, by which it means that it is the lower courts where the real case is prepared, and to improve the quality of the justice to dispensed with, it is necessary to improve the infrastructure by providing modern technology and facilitating the requisite staff to deal with the piled up number of cases in the lower courts. Another thing is that it is the state which acts as a prosecution in criminal cases. So there is a need of more transparency on their part, and public prosecutors should not only be selected on the basis of merit, but rather experience, efficiency, integrity by some transparent manner. Further, some permanent vigilance provision should be there to observe the working of the public prosecutors. Further, there is a delay in police investigation in the cases of murder and rape is not only the reason due to which cases linger on for years together, but rather it also helps the accused to destroy the evidences. And because of such delays, sometimes the important witnesses to the case became hostile, either under the pressure of the accused or to avoid the daily hassle that they have to face because of the police. It is therefore good to create an independent wing of police force to investigate into the murder and rape cases, and that wing should only be accountable to judiciary. Now further, the lack of coordination between police and the prosecuting agencies is another reason of delay. So there should be a good coordination between them as it will save time, which would have been taken in producing the arrestee to the court. The earlier disposal of case also boosts the morale of the police force and will have deterrent effect in the society also. The last one is that the criminal procedure code and the law of evidence have to be substantially amended so as to achieve this desired goal. Further, in the end, I would like to say that the concept of plea bargaining in murder and rape cases should also be used. In the end, I would like to conclude that in India, speedy trial in murder and rape cases has been given due attention which it required from years only after the heinous and horrendous crime that was committed at Delhi with a girl on a moving bus, and after that number of rape cases that has taken place in India. There is a need of quick and prompt trial in judiciary of not only murder and rape cases but other criminal cases also. The reason for delay in delivering justice in murder and rape cases and adopting such lethargic approaches towards one of the most important fallacies in the criminal justice system are unknown, but the apex court, by way of various judgments, has pointed out the plight of not only the victims but also of thousands of the accused standing for trial or awaiting trial. There is a need to take into consideration the suggestions mentioned and by seriously expediting the process of under trials, and this is the only way how Indian judiciary can decide the murder and rape cases within 6 months and can improve the criminal justice delivery system. Thanks a lot everyone.